Hello, everyone, and welcome to the legal knowledge portion of our training. My name is Sylvia Abdullah, and it is my great pleasure to introduce you to my colleague, Shalini Kohinur. Shalini is a lawyer and executive director at the South Asian Legal Clinic of Ontario. I am a former staff lawyer from Salco, and currently I'm working as a consultant with Salco as a partner in CASA's GBV project. My background is in immigration law, and my consulting practice entails working with organizations on various anti-racism, gender equality, and access to justice initiatives. Today, we'll be talking about a few important aspects of the law that are relevant to women facing gender-based violence. In the context of the study that CASA and its partners have undertaken, we will be looking at some of the common legal issues and needs of women in Canada who identify as South Asian and the barriers they typically face when seeking out legal help for GBV. We'll be looking at how some of these barriers were exacerbated during the pandemic. Immigrant, racialized, and/or newcomer women face a host of legal challenges when experiencing GBV. In addition to family law issues, they have to deal with immigration-related barriers when it comes to both leaving a situation of violence and seeking help. In our study of gender-based violence in the South Asian community, we heard directly from many women who identify as South Asian. Many of them also identify as immigrants and newcomers. For these women, immigration issues, family law challenges, and a lack of awareness of legal rights emerged as significant factors in the participants' experience of violence and the barriers they faced when seeking help. So let's dive into some of the basics of immigration law and family law as they pertain to gender-based violence. So Shalini, we'll start with immigration law. And I guess the first question I have for you is, what do you think are predominant issues that come up when it comes to women facing gender-based violence and immigration law?
That's a really good question. When I think about the predominant issues, really often a woman's immigration status is tied to their spouse or partner. And that really creates a barrier for leaving the relationship. For example, if you think about it, when a sponsorship application or work permit application is contingent or based on staying in that continued relationship, that really becomes a predominant issue when it's related to GBV and immigration law. Another thing that comes up often when we talk to people is the threat of deportation as a tactic that is often used by the abusive spouse or partner to keep the other spouse in the relationship, to maintain control, and to continue the violence. This threat is very often effective as most people on the receiving end are really not aware of their rights, and the abuser is often their only avenue to overcome things like language barriers. So the facts that are given to those people are often misrepresented by the abusive partner. That means that they're told, I can and do have the power to deport you, even though we know that's not true. However, we should really think that and understand that it is essential to know that the possibility of deportation depends on the status. So what that means really is that many people believe that staying in the relationship and maintaining the status is the only way they can avoid facing deportation.
So what is the case in reality? So if, let's say, if someone is a permanent resident or a citizen, could they lose their status or be deported just because they've left a relationship?
So the reality is that if you are a permanent resident or citizen, you cannot lose your status for leaving the relationship. That is the first line of defense, that you are safe from losing your status. Where it gets tricky is this understanding of misrepresentation. If your abusive partner then makes an allegation that you misrepresented yourself to get immigration and come to Canada, then there's a potential that immigration will get involved and investigate you. And these cases are called marriage fraud cases. Marriage fraud is a type of misrepresentation where a person marries someone with the purpose of getting status to come to Canada. Very different from what we're talking about, right? So in these cases, these are people facing violence who are leaving. They came with the intention of being married. There is no fraud there, but they are threatened with this idea that we will tell immigration authorities that you defrauded me to come here and then just simply left me, right? And we see this often in sponsorship cases where an individual is sponsored by their spouse or partner to become a permanent resident to Canada. So, as I said, often in abusive relationships, if the partner who's being abused leaves and they were the person sponsored here, the abusive partner will and can threaten to report to Immigration, Refugees, and Citizenship Canada by alleging this marriage fraud that I described, right? What is good to know there is that the person who left, the sponsored person or partner, absolutely has the opportunity to defend themselves against these allegations and to explain why they really left, that it was because of violence. And that would allow them to maintain their permanent resident status if they can provide enough reasons and explain that the relationship was one of actually of abuse.
Perfect. Thank you so much for clarifying that. And so I'm thinking about it from the perspective of, or in the context of, a woman who identifies as South Asian, or a racialized woman who's also a newcomer. I can imagine there being, even though there is that avenue of defending herself and showing evidence that there was abuse in the relationship, I can imagine that there would be barriers for women due to um, lack of knowledge of their legal rights, not knowing where to go for help, language barriers, right?
Yeah, absolutely. And I can imagine how terrifying it would be to suddenly get a letter from immigration authorities in Canada saying you're being investigated for misrepresentation because you left because of violence and abuse.
Right.
And that is really, really scary. And not just our own organization, Salco, but so many organizations across the country who do this work of immigration and its intersection with gender-based violence advocated very loudly on this issue. And I'm happy to say that in the past several years, we do not see as many cases of marriage fraud coming up from immigration, that there is a recognition by our government now that most of these cases are about violence and that abusers are often trying to use immigration to punish their sponsored spouse. But that being said, there are organizations across the country, including ours, where if that does come up for a person, they should feel free to reach out to those organizations. And many organizations are moving towards scenarios where they'll be able to get over that hurdle of the language barrier by either being able to speak the language of their clients or provide interpretation services.
That's great. So what about the scenario where someone is not yet a permanent resident? So let's say their application is still processing, or their spouse or partner has told them that, well, I will be submitting an application. So what happens in those situations if there's abuse and the person is thinking of leaving?
So this is a very tricky piece, right? Because we know as people who work in the sector of gender-based violence that what we want to tell people is we want you to make the decision that's the safest for you and to get out of the violence. But what does that mean when, like you said, they don't have permanent residence or citizenship, right? If a person does not have permanent residence and is dependent on their spouse or partner for continued processing of the application, it is certainly easier for that abusive spouse or partner to use the other person's precarious or non-immigration status against them to keep them in the relationship, to continue the violence. For example, those people can withdraw the sponsorship application if they have already submitted it. In some cases, the dependent partner finds out much later that an application for sponsorship has not even been submitted. We have seen scenarios where they thought it was submitted and it wasn't even submitted, and they've continued to stay thinking that this is happening, right? In cases where someone does not have permanent residence, they might still have temporary status. They might be a visitor, or they might be on a study permit or a work permit. But if that expires, they lose their status and they're sitting in their relationships without any status. It's important to note, though, that timing matters. Even if a visa has expired, they do have a 90-day window from when it expired to restore it. So if they happen to figure that out in that 90-day window, they can try and restore their status. But if that 90-day window has passed for restoration, they essentially are now here with a loss of status. They have no status. And so in those cases, they are still able to leave, but we then have to think about options that people will have to gain some sort of temporary or permanent status here, most usually through a humanitarian and compassionate application, which is sometimes called an H&C, or through a temporary resident permit, which we often call a TRP.
So what are those applications essentially? So what do we mean when we say an HNC application, and how do we define a TRP or a temporary resident permit?
And I think those are really important things to talk about because people do need to know those options. So an HNC, as I said, stands for Humanitarian and Compassionate Application for Permanent Residence. So it's an application that is trying to get you permanent status here. It is an exceptional measure that allows someone to apply for that permanent residence from within Canada on humanitarian and compassionate grounds, just as the term says. Normally in our immigration system, a person has to apply for permanent residence usually from outside Canada. The HNC allows you to do it from within inside Canada. And it looks at a number of different humanitarian and compassionate factors. And they can include health conditions, they can include the conditions in your country at home, they can include anything that would make it difficult for you to go back and apply and come back. They will always look at the best interest of a child in a situation, and they will look at your ties to Canada. How much ties and how much establishment do you have here, and how hard would it be for you if you were forced to return home? So there's a whole host of things that they look at. One of the other things that they do consider in the HNC application is also the violence you faced that has brought you to the situation of having to put this application in. On the flip side, the TRP is a temporary resident permit. So just by the name, you already know this is not for permanent status. This is for temporary status. And it is a document that authorizes a person who is inadmissible, meaning they can't enter or stay in Canada because they don't have status, because there might be a criminal issue, for all sorts of different reasons, and who does not meet the requirements of a temporary resident or as a permanent resident to enter or stay in Canada. So that sounds a little complex. What it is it's for people essentially who are out of status, who need to stay here temporarily, and who don't fit in any of the other neat boxes for temporary status in Canada to be a visitor or on a study permit or on a work permit. And so those are the people who would look at thinking about a temporary resident permit, a TRP.
That's great. Thank you for sharing that. So I think when often it gets confusing, like the TRP and the TRV, like there's a confusion between those two because one is a temporary resident permit and one is a temporary resident visa. But I think it's important to understand that a temporary resident permit is something that's provided in exceptional circumstances where a person is inadmissible, whereas a temporary resident visa is given to somebody or issued to somebody to come and enter and stay in Canada for a short period of time as a visitor. So that's a very critical distinction. So my last question with respect to immigration law, Shalini, is on the issue of temporary residence. So visitors, students, workers. So we know that some women are not necessarily, they don't necessarily come here as a dependent on a spouse. So not through the sponsorship route, or so they don't have a PR application, but maybe they're here as a student or a visitor or on a work permit. So what happens in those cases if they're in a relationship and there's abuse and they want to leave in terms of their status?
That's a great question, because you're right. Many people come here on their own on other permits and then meet somebody and the violence ensues. So if somebody lets their visa or permit expire, they will fall out of status as a result. So there are also cases where an individual might come to Canada on a spousal work permit if their spouse is on a work permit or a study permit in Canada. And so those are called accompanying work permits. So my partner has come on a work permit and then I get to come as a result, right, with that partner. In these cases, even if the relationship ends because of any reason, including violence, the spousal work permit will be valid until the other spouse's work permit or study permit is valid. Okay. So if I break up with my partner and his work permit is valid till the end of this year, so is mine, right? But once my partner's work permit expires, mine will also expire, and the problem is I cannot renew it under that ground anymore because I'm no longer with that person. So in these cases, what we say to people is you might be able to change your status from within Canada, but it is hard to do so. These temporary statuses from within Canada that are tied to somebody else can be hard to change, and it's up to the discretion of Immigration, Refugees, and Citizenship Canada and the immigration officers to decide if they want to do it. But at the same time, let's think back to just what we just talked about. There is also the option still of applying for a temporary resident permit, which is that piece that we just talked about. And in addition, in those temporary resident permit assessments, they will also look at violence. And there is a particular section now, a policy now that says that officers should be looking at violence in some of these applications.
Right.
And it's also good to know that when you fall out of status in these cases, the government really isn't usually prioritizing the removal of people who've lost their status in the way we just talked about. It's not a priority removal. So there's often a fear that I've lost the status, I'm going to be removed. We tend to find that this is not a prioritized area for removals. The priorities around removals still tend to be failed refugee claimants or those with criminal records. And so there's time, right? Yes, you are out of status. That's going to make things very difficult, but there is often time to be able to think about these other options. In reality, the truth is it is possible that someone can live in Canada without status for years. Many immigration practitioners have encountered these clients, and that they might only be removed when the Canada Border Services Agency decides to do so. But for those without status, life is hard, and it can be really difficult and precarious as there's very little access to resources and benefits.
Well, thank you so much, Shalini. That was super informative. I think we'll now move on to some basics of family law, because we know that that's also another area that's very, relevant when it comes to women facing gender-based violence. So in the study that CASA and their partners did, they found that the majority of the cases around family law issues included post-separation violence, stalking and harassment from the abuser, and the abuser intentionally not paying child support. So, and also after leaving an abuser, women's concerns included, wanting to make sure that, they went through the legal separation or divorce and they have arrangements made for children. Safety was also an issue, and mitigation of risk is something that they also looked for, since we know that violence is often at its peak when a relationship is ending, right? So my first question for you, Shalini, is can you tell us a little bit about divorce and separation? So what's the difference between the two and the general law around it in Canada?
Yeah, thanks, Selmi. And I think family law is a really critical piece of information for many of our clients. So let's talk first about divorce and separation. So separation really is when an intimate couple, and why I say intimate couple is because separation can be between people who are married or people who are in common law relationships. And separation is when an intimate couple decides to lead separate lives when the relationship breaks down. Divorce is a little bit different because divorce is a legal court process of ending a marriage. So it's important to note that an unmarried couple cannot and does not need to get a divorce. A married couple can separate and potentially never get a divorce, and a married couple can separate, and if they want to, they can pursue divorce, which is the legal court process for ending a marriage. So that's essentially the difference. And in Canada, family law is an interesting area that falls under both federal government and provincial law, right? So we have the Federal Divorce Act, which lays out the grounds for divorce. And that is often a question that people ask us. To get divorced, a married couple's situation has to fall under one of the following three criteria. The first one is that they have to have been separated for at least 1 year, so 12 months. The second one is that you can get divorced if a spouse has been mentally or physically cruel to you as the other spouse. And the third one is you can get divorced if a spouse has committed adultery. So those are the three grounds for divorce. To apply for divorce, One of the spouses must have lived in the province of Canada where they are applying for that divorce for at least 12 months or 1 year immediately before applying. So if I want to get divorced from my partner, I have to have at least I'm in Ontario, I have to have at least lived in Ontario for 12 months, and then I can apply in Ontario for the divorce. What is the process? The process of applying for divorce is set out in the provincial or territorial laws. So, for example, again, in Ontario, it is the family law rules that talk about the court process for how to apply for divorce. What's interesting is that often people say, okay, what's the legal process for separation? There is no court process to follow for separation. What you can do is simply separate. But the couple can always come up with a separation agreement with the help of lawyers and other services. And that's an agreement or a contract that lays out the rights and responsibilities of the couple once they separate. And so that's an interesting piece. You can separate. There is no legal thing that you have to do to separate. One thing that is important to do is to note and agree on what the date of separation is. And you can do that through a separation agreement, which sets out the rights and responsibilities of each of the people in that couple.
Great. And what about children, Shalini? What are some important issues that emerge regarding children? Because I believe that's also a super important area.
Very important area that needs to be addressed. And some of the most important issues regarding children that emerge during a separation or divorce include where will the child live, and how much time they will spend with each parent, and who will make the decisions about the child's life, right? So really you're thinking about the very big things that will impact a child's life. Whether a couple decides to separate or get divorced, they can always agree to a parenting arrangement out of court. So this can be done not through a court process. For example, they can do that through a process called mediation, and depending on where you are in the country, there are supports to do mediation. And if you cannot come to agreement, you can always go to court to help the court guide you in how to get those decisions made. If you go to court, you will have to apply for what we now call a parenting order. A parenting order sets out the roles and the responsibilities of each parent around the child. If the couple is going through a divorce, and remember I said you could separate and not go through divorce, or you could separate and go through a divorce. If a couple is going through a divorce, they will have to follow the rules under the Divorce Act in this area. If a couple was married or unmarried and have chosen to separate rather than divorcing, provincial and territorial rules will apply for parenting arrangements. So you can see here how that federal and provincial interplay works depending on which path you are choosing, right? And there are all sorts of different types of parenting arrangements to be made. Under the Divorce Act, the old terms that we used to call custody are now sort of changed. Now we use the terms decision-making responsibility, and that is what used to be called custody. And that refers to the parent's right to make major decisions about how to raise for and care for their child, where they might go to school, the provision of help, what sports they might join, what faith they might follow. All of the major decisions come into play. The other piece after decision-making responsibility, which used to be custody, is parenting time, which was formerly known to most people as access, and sometimes they called it visitation. We now call it parenting time. And that means the amount of time a child spends under a parent's care. Some provinces in this country may still use the terms custody and access, but the federal legislation changed and most people are shifting to decision-making time and parenting. A parent can have sole decision-making responsibility or joint decision-making responsibility with the other parent. Parenting time can also have different variations. So what I'm trying to say there is there's a wide range of ways that these decisions can be made. Decision-making time can be split, or it can be only one person, or it can be one person for certain things, another person for other things, a whole host of different ways in which you can set this up. Parenting time, the same way. Who will the child live with? When? How much time do they get to spend with each parent? A whole host of For example, a child can be with one parent for weekends only or have shared parenting arrangements or orders where they spend at least 40% of their time with each parent. In a situation where there are safety concerns, there can be supervised parenting arrangements where a third party person supervises a parent's visit with the child. So you can see there that there's a lot of flexibility, and what they're really thinking about is what works for this family and what is in the best interest of this child.
Right. Thank you for that, Shalini. So on the topic of best interests, how does family violence factor into parenting arrangements? I know we talked briefly about safety and supervised visits. So I guess that's an example of how the best interests of a child is taken into consideration in situations where there's family violence. So how does that work usually?
Definitely. And I think what's happened in Canada in particular over the past couple of years is that we've moved ahead a lot in understanding the impact of family violence on family law situations, and that now there are pieces in the Divorce Act that speak directly to that. So ultimately, any kind of parenting arrangement that's made is always going to be based on the best interests of the child or children involved. And the Divorce Act now tells us that family violence is a relevant factor in assessing the best interests of the child. The court has to consider whether someone who has been violent towards their family members can adequately care for the child and whether the parents can cooperate on parenting matters. And so when there is family violence, it has to be assessed now when parenting arrangements are made.
Okay, thank you. And what about finances, Shalini? So after separation or divorce, what rights does a woman have when it comes to financial support or the property that she had during the marriage?
Okay, so let's unpack it a little bit. Married couples who decide to separate or divorce can apply to the court or come up with an agreement outside of court to divide the property that they shared during the marriage. If they apply to the court, the division will happen through a process that we call equalization, meaning each spouse gets an equal share of the financial gains during the marriage. In Ontario, common law or unmarried couples cannot apply for equalization. So that is sometimes a real challenge. Rules around property division are determined by provincial and territorial laws. So depending on where you live in the country, the process will look a little different. And as we said in Ontario, common law and unmarried couples cannot apply for equalization. So all of those rules are a little bit complicated, and on the division of property, it is very important to seek the advice of a family law lawyer if you can, so that you can get it right and determine what you're entitled to depending on where you are in Canada and what your relationship looks like. Beyond that, the property division piece, of course, there's the other financial piece. We know that spouses and children can also receive financial support from the other spouse following a divorce or separation. And this is known as spousal support and child support. Again, just like everything else we've been talking about, this can be done through an agreement if you can come to one, or if you cannot or you choose to do so, you can do this through a court order. For married couples, again, the Divorce Act sets out the rules for support. The rules for unmarried couples are laid out in the provincial and territorial laws. So again, you need to figure out, depending on what your relationship looks like, which piece of legislation you're going to follow. So oftentimes clients ask me, well, tell me about spousal support. What is that? Spousal support is paid by one spouse to financially support the other to compensate for economic disadvantages faced by that spouse during the marriage. What does that mean, really? So, for example, through giving up their career to raise children. And we see that often. We see people where one spouse works, one takes a back seat and maybe stays home for part of the time or all of the time to care for family. And so their ability to jump back into work if they happen to separate or divorce is much harder. They're also thinking about how to reduce financial hardship for the spouse and encourage the spouse to become self-sufficient. So that really is what spousal support means. Child support, on the other hand, probably you can guess, is an amount that one parent pays to the other to help support children. The amount of child support is calculated based on federal and provincial child support guidelines. If the couple never married or was married and decided to separate and not divorce, the provincial guidelines still apply. Why is that important? Because in child support, it doesn't matter. It doesn't matter if you are married. It doesn't matter if you are unmarried. If you've had a child together, one parent is obligated to pay child support to the other parent. In cases of divorce, the federal guidelines will apply except in the province of Manitoba, Quebec, and New Brunswick. So that's an important distinction as well. One thing to note about spousal support and child support. Child support is mandatory. And so if you've had a child with another person, the person who's not caring for the child will have an obligation to pay child support. Spousal support is not mandatory. Spousal support looks at all those factors I talked about to try and figure out, does this person qualify? And so either you have to come to an agreement or seek that order in court in either case.
Okay, perfect. Thank you. That was very detailed and very clear. Thanks, Shanley. And I guess we're reaching near the end, but there are a couple of more questions that I would love to ask you. So what are some of the things that women can do to ensure that they and their children are safe? Because safety is a huge piece, right, in family violence matters.
Yeah. And we know that the risk of violence is often higher after a woman leaves a relationship. So at the point of leaving and after they leave, the risk of violence can often be higher. So in family court, we think about something called a restraining order. A restraining order can help protect one's safety from an abuser who is a partner or an ex-partner. So an application for a restraining order can be made in a family court. It sets out various conditions for the abuser, such as the abuser cannot come within a distance of their partner, their children, their home, their work, and cannot communicate with or contact the partner or children except through a third party. So those are really a protective thing to get a restraining order through the family court when violence is at play. In family violence cases, a woman can also apply to the court to ask for exclusive possession of the home where the couple lived until separation. That we call the matrimonial home. So the motion is called an exclusive possession motion for the matrimonial home. And what does it mean? Exclusive possession means that the court can have the abuser move out of the home temporarily and allow the other spouse and her children to live in it. But it does not mean that the spouse living in the house can sell or mortgage the house without the consent of the other spouse who has been asked to move out. So those exclusive possession rules are laid out in provincial and territorial law. So those are the two pieces to think about as well. In addition, the restraining order to keep your abuser away, and the exclusive possession to keep you in the home with the abuser not there.
Great. And the final question I have for you is regarding where women can go for help, and how do we reduce the barriers that they face as they're trying to get help for their situation? Because we have seen this, we already know that racialized women, newcomer women, immigrant women face a host of barriers, as we were speaking about earlier, when they seek help, and that was exacerbated greatly during the pandemic, right? When agencies were also at capacity and were trying to sort of figure everything out in the midst of this catastrophe or disaster. So how do we, as agencies and service providers, what are some of the ways these barriers can be reduced if we're speaking in the context of South Asian women in particular, and where can women go for help?
Absolutely. So I think the starting point is to understand that on the legal side, on what we call access to justice, across the country, the resources in family and immigration law, particularly for people facing situations of violence, are not good. Right? And that has been the struggle and continues to be the struggle. So depending on where you are, you will have more or less access to resources. And I'll talk to you about Ontario, where I'm situated. But one of the first things that we can do are things like this, where we can get this information into the hands of people facing these situations and into the hands of other workers who work in this field, so that they can at least have an understanding at a beginning level of what to do. Second, depending on where you are in the country, look to see if your province or territory has a legal aid service. Most do, and in most of those areas, family law is a priority. So you will look to the legal aid services that provide support in family law. In Ontario, that would be Legal Aid Ontario in particular. And then sometimes legal clinics can give you family law advice. In Ontario, Zoe, we have a pretty phenomenal website called Steps to Justice, which takes you through different family law processes. And we have some specialty services like the Muslim Legal Support Center. So the starting point, if you were in Ontario, would be to contact legal aid, would be to contact a legal clinic for South Asian clients. We are the South Asian Legal Clinic of Ontario, and we do support clients in multiple South Asian languages, and to contact spaces like us. In other provinces, look for the legal aid services that connect you to family law as well. And finally, what is really exciting is the federal government is now rolling out specific projects to cover immigration and family law services in these areas. So recognizing exactly what we've said. And so now more than ever, you will see new projects in the Maritimes, in Nova Scotia, Newfoundland, New Brunswick, through Quebec, through Ontario, through the Prairie Province of Manitoba, Alberta, Saskatchewan, right through BC. And so we do now have these new projects popping up that are designed to provide you with the basics of information and support to navigate both immigration and family law issues.
That's fantastic. Thank you so much, Shalini, for your time today and for sharing your expertise with us. This was super helpful and informative. And to our attendees, we hope that you found this helpful as well. Thank you, Shalini.
Thank you.